Welcome to Benson on Injury Law.
Welcome back to Benson on Injury Law with Paul Benson. Paul is a personal injury attorney based in Wisconsin, and he spent the last decade helping people across the state understand their rights and get treated fairly after serious injuries. I'm Lisa Mosbey, and today Paul's breaking down the steps in a lawsuit from start to finish. Welcome, Paul. Thank you so much for joining me today.
Hey, yeah, thanks for having me. Good to see you.
You know, Paul, when someone first decides to move forward with a lawsuit in Wisconsin, what's the very first step in the process?
So a lot of times, by the time we get to the point in the case where we're filing a lawsuit, we've probably already gathered all of the information and we've attempted to settle the case, informally, often with the insurance company. So when it's time to actually file the lawsuit, it's normally, it looks like confirming information from the client. So I'm going to set up a meeting with my client, make sure that we have all of the facts, dates, addresses, make sure we have all of that correct before we put it into a pleading with the court, a formal document with the court. And then we're also going to make sure that our file is in good shape. So that means, do we have updated, medical provider information? Do we have updated health insurance claim information? And we make sure we have that case all the way ready before we put it into suit. The reason we do that is once we put the case into suit, we're now going to have a scheduling order and court deadlines that in some cases could, make it harder to prepare the case. So we want to do all of that work on the front end, which really speeds things up overall.
And then, Paul, once a case is filed, what happens next in terms of the early paperwork and getting the lawsuit officially started?
Yeah, that's a great question. So the first step is we have to get the defendant, the insurance company, and let's use a car accident case for an example of the other driver. We need to get them served with the papers. So in Wisconsin, the case does not commence, it does not legally start until that person is served with the complaint and the summons. After that, we'll enter kind of the discovery process. So we will send written discovery requests to the other driver. And we'll also start probably preparing responses to their written discovery requests with our client.
And discovery can sound intimidating, in simple terms. What is it and why does it matter?
The formal process laid out by our rules of civil procedure that allow the parties to exchange information. So the idea in Wisconsin is we're going to have no surprises at trial. So both sides get to learn everything they want about the other party within reason during this process called discovery. The main two areas of discovery are those written discovery requests and then depositions. Those are the two main types of discovery.
People have an idea from watching TV what depositions are, but in your terms, in your words, how do depositions work, and what should people know about what actually happens during one of them?
So, a deposition is under oath testimony, just like you're in front of a judge. And it's the lawyer's opportunity to ask you questions, really the only opportunity to ask you questions before you get to trial. So let's again use that car accident example. What that's going to look like is normally the defense lawyer will come to my office, the court reporter will come to my office, and then my client, the witness, will come to my office, and the four of us will sit in my conference room to take that deposition. Most depositions take in a car accident case, on the short end, I see defense lawyers only spend an hour and a half. On the long end, sometimes 3 or 4 hours. Typically, defense lawyers are pretty formulaic, so I can really prepare my client for exactly what that deposition is going to look like, and we'll do that in advance. I always insist on meeting with my clients in advance to go over what to expect in that deposition.
And this is my follow-up question to that. How do you calm their nerves during that process? Because that is so intimidating for those of us that don't work in the law daily.
It can be intimidating. What we do is I try to meet with them. The people who are especially nervous, we won't do that meeting, over Zoom or on the phone. I'll let them come into the office and we'll actually rep some of those questions. So I will ask some of those questions and I'll try to ask them in a little bit more aggressive or combative way than I even think the defense lawyer will, to try to prepare them so they see what to expect. And hopefully that calms the nerves. But to be honest, people are always nervous. So that's just kind of part of it. And I think that everyone expects you to be nervous. So I always tell people, don't worry that you're nervous. A jury would expect you to be nervous. The jury probably would be nervous too. So just do your best to tell the truth and don't worry about being nervous.
And I know the next part that can be intimidating is after the depositions, the experts come in. So, at what point do experts or medical providers get involved? And what role do they play in moving a case forward?
Cases, especially, where there's significant, long-lasting injuries, can be very, very driven by expert witnesses. My preference is actually to line up our expert witnesses before we put the case into suit, for the reason that I said. Some judges get very antsy about their calendars, and they'll say, you've got 90 days to disclose your expert witness, and I'm not going to give you any extensions. And that can be sometimes very challenging because it's outside my control. What if my expert witness has, I don't know, something come up in their personal life or their work life? Most people are not full-time expert witnesses. Often it's like, maybe a surgeon who does some expert witness work on the side. If they miss that deadline, I've now prejudiced my client. So my strong preference is actually to go through all of that on the front end of the case before we put the case into suit. Sometimes that's not practical for various reasons. It doesn't work. Maybe sometimes it's a case with less significant injuries and we're just trying to change the paradigm and increase the settlement offer. There are times where I'll put that case into suit before we hire experts. But generally speaking, when you say at what point do they get involved, I like them to get involved before the case. The defense experts is kind of the opposite. They normally don't get involved till maybe often 6 months or a year into the case after my client's deposition's been taken. That's normally when the defense will get their medical experts involved.
And Paul, many cases settle before trial. What usually leads to settlement discussions, and how does that process unfold?
Most of the time, the court will order us to attend mediation before we're allowed to go to trial. So the judge will require that we complete mediation by a certain date. Mediation is a fancy word for a settlement conference, and that normally takes place after discovery and after at least the plaintiff, so in my case, my client, the injured side, after we've disclosed our expert witnesses. That's normally the sweet spot when everyone really probably has a good grasp on the facts of the case and can come to a settlement conference in good faith. So after discovery, after a plaintiff discloses their experts. And disclose just means I file our expert report, like that expert's written report with the court.
And then for those cases that do go to trial, what should someone expect inside a Wisconsin courtroom?
Trial like that can last anywhere from 1 to 2 days, all the way up to 2 weeks. It really depends a lot on the specific facts of that case. Some things are always the same, though. We'll always start the first day by picking a jury. So we'll spend at least the first morning, sometimes the first full day, selecting a jury. After that, both lawyers get to give their opening statements. A common way that the judges here in Rock County do it are, in the morning we'll pick the jury, in the afternoon we'll do opening statements, and that's it for the first day. After that, it's my turn. It's my turn to put my case on, the plaintiff side of the case, where I'll call all my witnesses. So let's, again, talk about just a typical car accident case. That means probably calling my client and maybe their spouse, but also calling key medical providers and maybe some other witnesses, friends from work, colleagues, things like that, who could testify about how the accident really affected them day to day. After that, the defense gets a chance to put their case on, followed by closing arguments, and then the case goes to the jury. That's the hardest part, because the case is in the jury's hands, and you're just waiting and waiting. And I've had cases where the jury, deliberates into the next day and even 2 days, and that's a hard process for you and your client, just sitting there waiting for that phone to ring.
And I know you've sat with many, many, many clients, many who started off very anxious and nervous about the whole process. When a client starts off very nervous, in your experience, how do they end up feeling more comfortable once things get underway?
In my experience, once they get their deposition out of the way, clients feel a lot better. I also think that my clients, they work directly with me. I don't have any
Oh.
other lawyers in my office. I have staff that help me, of course, but I'm the only lawyer. So we've hopefully built a good relationship, a good rapport by then. And I think that helps them feel more comfortable as well. But normally it's getting that deposition out of the way. And as long as we prepare them for that, most of my clients afterwards will tell me, well, that went exactly how you told me it was going to go. Maybe it was still nerve wracking, but normally after they get that deposition out of the way, they feel a lot better because that's really the toughest part of the case.
The word that comes to mind for me is trust. You have to build trust with that client that you've got them. They're in your hands and you're going to move this forward. What are some steps you take to build that trust with someone?
I think it's meeting with people in person. I think in this modern time we live in, there's over reliance probably like on text messaging, emailing, and even like Zoom and video calls. But I don't think there's any substitute for meeting with people in person. And I will say sometimes circumstances dictate that I have to meet with my clients over video or things like that. And I do struggle to get as good of a connection with my client as I do when I'm able to meet them in my office in person or even at their home or in the hospital. However, we first start meeting, that is my preference that we meet in person for sure at the outset of the case. And then again, when we put the case into suit and we meet, we go over the case and we make sure that we're meeting in person and we're spending that time to get to know each other and spending that time prepping them so that they're ready for those challenges like their deposition.
And I know you've talked about all the moving parts of a case. I think one of the big ones that can be a red flag in my mind is the follow up. How do you keep connected to these clients? How do you make sure that they're up to date? Because when there's gaps in time between things happening, we get in our own head. Our thoughts kind of can get away from us. How do you handle that?
That I would say that's the challenge that every lawyer has because litigation is slow. Litigation is really, really linear. Like one thing has to happen before the next. And sometimes that can take a long, long, long time because our rules of civil procedure are set up in a way to make sure that everyone gets a fair shot and no one can complain by the time they get to trial. Everyone can say, hey, I had full opportunity to review all the evidence and gather all the evidence I need. What that means is it's enormously slow. So I do try to check in every couple of weeks and at least say, hey, we're still in this phase waiting for this to happen. Um, and that can take a long time, but it is hard. It is hard because litigation is it's a slow process. There are ways to try to speed it up, but my hands are somewhat tied by the rules of civil procedure and by the judge and by the defense lawyers. I mean, for example, we talked about depositions. In many cases, you might have 3 or 4 different parties, which means 3 or 4 different lawyers. You have to get all of them plus the witness plus the court reporter to agree on a date, for a deposition. Sometimes that can take a month or two just to set a simple date, which sounds foolish, but in practice, unfortunately, that's how it happens because things happen. You think you have a date, and then the judge or maybe one of the defense lawyers has another hearing come up, and we have to get that moved. So what I would say to that is I do my best to be proactive on it by sending a text or an email saying we're still waiting for this, but it is a long process.
Staying in touch, I think, is so critical. When people have a good relationship with their attorney, they've built trust, they know that they're handling it, and they're going to follow up with me. For someone listening who's hesitant about filing a lawsuit because they don't know what to expect, what would you want them to keep in mind?
First, I'd want them to know that we may not have to file a lawsuit. Many claims can be settled before we even get to that lawsuit phase. Number 2, a lot of people assume that means going to a trial. Most cases settle long before a trial. So even if you're filing a lawsuit, that doesn't mean that you're going to be on trial like something that you see on TV. There's a good chance that case will have an opportunity to settle before you get all the way to trial. Third, you're not alone. I'm going to be there with you. I'm going to be there to help you and guide you and take the lead on this. And your involvement, while important, will be really focused in a couple key areas. And it's not like it's not going to have to dominate your life like maybe you see on TV. In fact, I recommend often prepare for your deposition, prepare for mediation, help me prepare the discovery. And then I say, don't stress about the case. put the case on a shelf, try not to think about it. Let me handle it. It's what you hired me to do.
Well said. Paul, thank you so much for walking us through this process today, and thank you for your time.
Thanks, Lisa.
Folks, thank you for listening to Benson on Injury Law. If you're thinking about a lawsuit but aren't sure how the process works, you can get clear, straightforward information at paulbensonlawfirm.com. And don't forget to like, subscribe to the show, and come on back next time. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.